Welcome, everybody. My name is Luke Hogg. I'm the Director of Tech and Telecom Policy at the Foundation for American Innovation. I'll be moderating this wonderful conversation. I want to let my panelists introduce themselves in just a second, but I also want to note, if you go and look on the agenda, the description for this panel is very vague. So we're going to be covering a lot of territory and talking about a lot of stuff. And I think the general thesis is we want to talk about not only case law in the First Amendment, but what does speech mean? How has it changed over time? How is it going to continue changing? So really looking forward to a wonderful conversation. I'll pass it over to Joel to let him introduce himself.
Hi, Joel Thayer, president of the Digital Progress Institute. I also serve as a senior fellow of AI at the American First Principles Institute. I know, it's been a long life, but I'm here more in my DPI capacity and looking forward to this conversation. I like the framing.
Corbin?
Corbin Barthold. I'm Internet Policy Counsel at TechFreedom. I'm also a member of TikTok's U.S. Content Advisory Council, and I'm here in no capacity. Just say what I think. Yeah.
You're incapacitated.
Are you at least here in a physical capacity?
Anyway, individual.
I'm an ace role play. Yeah. Oh, hi. Do you want to try and say my name?
No, not really.
Hi, everyone. I'm Ashkhen Kazaryan. I'm Senior Legal Fellow at the Future of Free Speech at Vanderbilt.
So I guess to kick us off, there's been a lot of conversation today and just in general. It is the 250th anniversary of the United States of America. It is not the 250th anniversary of the First Amendment, but we're going to kind of lump that all in together. It's the 30th anniversary of Section 230, and I thought there's no better place to start this conversation than way back in the beginning. And it's interesting because I'm currently working my way through Ron Chernow's biography of Alexander Hamilton. And there was a little anecdote that really struck me, where way back in 1776, there was a man named James Rivington who ran the New York Gazetteer, and he was a Tory in New York. As the Sons of Liberty and more radical sides of the independence movement were getting going in New York, there was a mob that raided this man's newspaper and crashed and destroyed his ability to publish his newspaper because it was seen as being in line with the Tory cause. And at the time, Alexander Hamilton tried to stop this mob and later wrote to John Jay, quote, "In times of such commotion as the present, while the passions of men are worked up to an uncommon pitch, there is greater danger of fatal extremes." And I think this is a really interesting way to think about what the founders were thinking at the time around the importance of the freedom of speech, the importance of what would become the First Amendment. And so I think a really good place to start this conversation is actually around what has changed since those original conversations were being had around the Declaration, around the constitutional conventions. So I guess just going down the line, I want to start with you, Joel. Since the founding, there's been a lot of changes in technology and changes in the ways that people speak and what speech really means. So how do you think and how do you conceive of the concept of how technology has changed what speech is, what it means, and how we conceive of that concept of speech?
Yeah, it's a big question. So I guess I think about it in three distinct buckets. And I like the original framing that First Amendment protects. And so if we were going back to an originalist perspective, it gets far narrower if you look at the actual constitutional historical literature. So part of it is just a ladder debate on the First Amendment, and everything else will probably get resolved mostly at the Supreme Court level. I'm very interested to see how the court is grappling with this idea of originalism, some of the things you brought up. Like, what did the framers actually think? You're seeing more citations to the Federalist Papers, like Federalist 44 has been cited in quite a number of different opinions, but most prominently in the First Amendment context, you saw that with the Free Speech Coalition, the Paxton case, in which the Free Speech Coalition was challenging a Texas law that age-gated pornography. But the other issue that you raise, I think, is very interesting, is this evolution of technology and the mediums that have changed. And so the way I look at that is more or less a question like, is private censorship better or worse than a public censorship regime? And I think it can be demonstratively worse, as we've learned throughout the past 10, 15 years. So to quote my good friend Gail Slater, I'm just as much concerned with tyranny.gov as I am tyranny.com. So there is that aspect of it. And then the third bucket is going back to what the First Amendment actually means. I think the First Amendment, the text alone, invites at least a historical review of what they were trying to do, what the framers actually thought, especially when you look at the precise text of what does abridging free speech actually mean? That implies that your free speech doesn't come from the government. It comes from something higher outside of positive law. I don't think it's any secret that the framers were pretty religious and they were evaluating issues on the natural law side of things. And so I think it comes down to what aspects of how can we look at what they were thinking about at the time and apply it to modern day. And it's a very interesting question that undoubtedly will get teased through the appellate process. And I think you're already starting to see that.
Yeah. So Corbin, Joel brings up this word tyranny, and it's interesting because when I'm thinking about this context of that anecdote I just gave, that's the tyranny of a mob against a newspaper going in and people literally destroying the printing press. How do you think about these questions of speech and these questions of power as they've evolved through technology from back in the day when you're literally printing on pieces of paper to now when, nobody uses paper anymore?
The technology has obviously changed dramatically, and that has changed the environment for speech. But I actually think we've come full circle when I look back through American history. You mentioned a mob. John Jay got hit in the head with a rock. There's a lot of that kind of rough and tumble in Hamilton. It's a great book. I like to say Americans are not house trained. Philip Roth had the phrase indigenous American berserk. Our speech environment has always been extremely sharp-elbowed and chaotic. Another thing that's fun in Hamilton is getting to read the letters of our leaders and how much they thought everything was going to pot and we were all going to tear each other apart and that everybody on the other side was their mortal enemy. So we've always had a very wild, rough and tumble, aggressive speech environment. And we see that in the founding with all the scuttlebutt in papers, James Callender going around maligning the leaders of the country, sometimes actually quite accurately with their personal failings. And this concern about, well, we need to have high-minded civic debate. And no, we've really never had that. We've had people slandering each other in pamphlets from the very beginning. Thanks to technology, the way I view it is we actually had something of an interregnum in the second half of the 20th century, where with the rise of technologies that were facilitating one-to-many speech, for about 10 seconds, we had a very uniform culture of speech around 3 broadcast stations, a probably monopolistic newspaper in your region, and a few radio stations and magazines, and that was it. A lot of the rough and tumble went away, a lot of concerns about corporate power in speech. And with recent developments, I actually see us coming back around full circle, where for all the fears about private censorship, we have a completely wide open, rough and tumble speech environment again. The rise of podcasters, the rise of alternative media with sites like Pirate Wires or Free Press or Compact, the rise of all the platforms we need to remember that are out there aside from the major ones we always think of, Discord and Reddit and WhatsApp and Signal. A lot of the best conversations are currently occurring in Signal group chats.
As made evident by this administration.
Yes, this is true. To me, things now, maybe just fortuitously by the way the technology has changed, we're back to a very similar environment to what the kind of stuff that the founders would have recognized. Things are quite open. We have Martin Gurry's Revolt of the Public, where when information is abundant, it's very hard for anybody to speak with authority, because the public is always capable of speaking back. And we see that on social media all the time.
So Ash, I'm curious if you agree with Corbin's assessment there that we've come full circle. And then I guess a follow-up on that, assuming, I guess, whether or not you do agree with Corbin on that, is this question of how does this change how do you feel like our conception of perhaps not freedom of speech, but specifically the First Amendment changed over time? Because if we're going back to those original ideas of the founding, it would seem like we would have a similar conception of freedom of speech now as they did then, but I'm not sure if that's necessarily the case. So first, what do you think about
what? You asked me like 4 things. Let's go one by one. Let's go backward.
There you go.
Great questions, though. The first one being that think the current First Amendment, as we know it, wasn't there this whole time. That precedent, the body of precedent, mostly had developed, I would say, in the past 50. I'm like bad with math because I think like I was born 10 years ago, but like past 50, 60 years is when the meat of the First Amendment as we know it now has developed. Now, in my personal opinion, the current interpretation of the First Amendment, which is the strongest free speech protections in the world, is the right one, and the Supreme Court has come to it. But it wasn't always that. Like, I do find that weird when sometimes people are like, oh, like the First Amendment was always this great. It wasn't. We had come to it through different historical events and changing of the composition of the Supreme Court. I just do think that we ended up in the right place. Now, will we stay there or not is still a big question. So that's the answer to the first, actually the last question you asked. And then the one before that was, what was it?
Do you agree with Corbin that we've kind of come back full circle into this sense of that many-to-many speech, like we're back in the Wild West for speech, if I'm paraphrasing
Right.
Corbin here, but
I think there are more mediums that we communicate through. So in a way, it is the most decentralized we've been in a while, and there are more opportunities. So while I do agree with Corbin, and he probably knows more about, actually he does for sure know more about history than I do. In my opinion, while we have come back to more decentralized, like we have more forums for speech, I don't think it's the same as it was in like 1791 in the sense of like opportunities to express yourself and also possibilities to do so. But I think the principles and the mechanisms behind it are maybe similar.
So taking us a little bit out of the realm of kind of principles and into the more pragmatic, it's interesting that you bring up the idea of decentralization of speech. At the same time as we have radical decentralization of speech, it also sometimes feels like we have radical centralization, which leads to lots of questions around kind of platform governance decisions and how these work. And I think nowhere have we seen this more concretely than in these questions around algorithms. And what are the algorithms doing? Are the algorithms speech themselves? Is it corporate speech? How do all these kind of come down? And I think one of the really interesting questions that I'm going to pitch this to you, Ash, first, and then get the rest of the panel's opinions is, are there distinctions that we're missing? It seems like when we talk about the algorithms, it's just like this one big behemoth, but algorithms do a lot of different things. So are there distinctions that we're missing in some of these conversations around algorithms, specifically with regards to, is there a distinction between removing content versus suppressing content versus labeling content and amplifying? Where are there distinctions that you think are important in some of these conversations?
I think practically, obviously, different types of algorithms doing different things like suppressing content, amplifying content are practically, in content governance sense, very different. But in my opinion, and maybe this is when it gets exciting for you guys, but in my opinion, I think when it comes to the legal side of things and the question of the First Amendment and other legal mechanisms surrounding it, they are just tools that platforms or individuals who are using algorithms use to exercise their editorial decisions and their editorial discretion. So in that sense, from that side, like if someone from a court bench is looking at it, I think it's the same.
So Joel, I'm going to come to you next because I think I'm going to assume that you have a little bit of a different take here than I think Ash does. What do you think about these questions around platform governance and where the line is between kind of governance decisions around content, corporate speech, and traditional questions around power and speech?
Well, it's an incredibly important question. Actually, I don't think I'll necessarily deviate too far from where I believe Ash is getting to, which is that there are these different concepts of speech. And the question I think that a lot of folks are grappling with is what is being communicated here and what are the algorithms communicated to the extent they're communicating at all? And who has the speech interest? And again, I think you're absolutely right in terms of the framing that, yes, you can make the case that there are probably a lot more platforms, but there are choke points amongst all these platforms in which you have to work with at least some of them at some point. And the question is, are these, I hate to borrow this term because I can't think of a better term, but there are these aspects of gatekeeping that does exist, from whether or not you want to have a Discord on your phone. That goes through either one of two app stores. If you want to generate some ad revenue, well, there's only one of two ad exchanges that you can work with. So again, I think that there are these levers that are getting pulled in the background. So to the extent that there is these wider plethora of different platforms, I don't know if that's all that meaningful in terms of the questions of speech. And if you're talking about an originalist perspective of how we've thought about speech, I think that in the past 20 years, we've gone completely out of bounds in terms of what the founders actually thought of these speech interests. So I think I agree with Corbin in terms of the full circle, but I'm not sure if I agree with where we started, where we ended up. These different decentralization aspects are leading us back to a fundamental question is like, what do we value? What do we want to protect? What is protected by law? What are the particularized speeches? And which is why you're getting a lot, in my opinion, far more sophisticated court decisions, at least at the appellate and the Supreme Court level, asking basic questions of, okay, so tell us what the speech interest is. Tell us, is this your speech? Is this someone else's speech? And then you couple that. I mean, I think it's a bit of providence that we, maybe not, maybe it's actually a reason why we started at this time, but I find it interesting we started talking at 2:30. And so you have these other aspects of these statutory, I would call them government gifts, where essentially allowed this untethered view of what a speech interest is, which basically amounted to, and as trite as it might be, this almost like First Amendment Tourette's that we see from like the tech industry, where by virtue of adding an electron to a particular service, that there's an inherent speech interest, I think is completely ridiculous. So I think you're also starting to see that courts are responding to that, and they're asking very, very specific questions. The first question, in fact, in the TikTok case, which is where we tried to impose a foreign ownership obligation, we did impose a foreign ownership obligation onto a platform. The first question that Justice Thomas had to TikTok's counsel was, what precisely is your speech interest? And TikTok had a very difficult time explaining it. And I think that type of analysis is going to keep coming. I don't think the courts are buying this First Amendment wholesale defense, especially when you compare it to some of the other case law that you're seeing in Section 230 and how they're bringing those defenses in. So at what point, who is speaking? Is it your speech? Is it the user's speech? Who actually has the right here, and who is the one that the law is determined to protect? And I think that's what's going to play out more and more as we get higher and higher up into the court system.
So I didn't think that we were going to get to Providence in this panel, but I guess that's my fault for bringing up Hamilton. I think
Rhode Island?
Corbin, I want to give you an opportunity to respond just to what Ash and Joel are saying here.
Good. I thought Providence was going to be some tech company that I hadn't heard of. Okay, you mean big picture Providence. I think Joel is right about the need to...
Thanks, everyone.
The need to parse distinctions, and we might just come to different conclusions about what that process will lead to. So some of the concerns that people have once you scratch below the surface don't necessarily add up. So under current Supreme Court law, monopoly power for a certain editor, actually you maintain your First Amendment rights under Miami Herald versus Tornillo, which makes a lot of sense when you actually look at how fluid these markets tend to be and how quickly they move. If you get up to the level of having literal gatekeeper control, flip switch control over, say, a cable connection under Turner, we know, okay, there is eventually a point you become so powerful that a law regulating you might be subject only to intermediate scrutiny. I think in most of these contexts, plaintiffs...
Not all of them are lawyers. What is intermediate scrutiny?
We look at the law and we are more likely to allow it to stand than we are if we apply strict scrutiny, which is what happens if you do a frontal attack on the First Amendment by saying we want to regulate the content of your speech or what you're allowed to say. I think it's going to be an uphill battle to show that kind of power in any of these markets. We recently had the Facebook antitrust case, and I think a lot of people look at Facebook, for instance, and it feels like it's super powerful, and then you do the market analysis, and well, I mean, Facebook hasn't been cool for a very long time, and so their market share is not actually that high, and so the antitrust case gets thrown out. The main thing I think people are interested in is algorithms on the actual expression-facing part, what they actually see. And we see this a lot where, yes, it's important to understand what the technology is or where the electrons are flowing, but what people ultimately care about is the expressive value at stake. And just because there's some kind of new technology doesn't mean that there's no expressive value. So another place I'll agree with you, I thought it was a catastrophe the way you had TikTok coming out and sort of giving their interests first in the Supreme Court oral argument because the listener interest is much bigger. But the lawyer, Jeffrey Fisher, trying to represent the interests of users came up second, and that interest got sort of buried in the case. So it may be the case that you don't feel sympathy for the speech rights of a particular speaker, and yet you still feel strongly that listeners have speech rights to have particular expressive products on the market. and that the second best world in which we live is still superior to letting the government seize those means of expression and take control over them. We have Moody versus NetChoice, so that's the Supreme Court saying that algorithms are protected by the First Amendment. We'll see where that goes. It was technically dicta in that decision, although I assume they will stand by it. It makes a lot of sense. There are infinite ways that you can use algorithms to send this message and not that is fundamentally expression. Maybe there's a problem to repeat if there's a certain level of market or gatekeeper power, but that threshold is going to be very high. And I would say what we need to do is maintain focus on people's right to a variety of different formats of information, different varieties of information. If they don't like the algorithms here, they can go and see them somewhere else. My one qualm with how that law has gone thus far is that Amy Coney Barrett wrote one of the most impactful, I hate that word, concurrences I've ever seen, where she said, well, what if the algorithm is just giving the user exactly what they want? Maybe there's no First Amendment right there. And I don't really see how that stands up. Even within the narrow universe of giving a user what they want, there are all kinds of expressive choices in terms of content moderation and trust and safety, things like avoiding spam. But then it's also that metaphysical concept falls apart. There are lots of different ways that you could give a person what they might want to see. There are various things that might, say, capture my interest. There's not one platonic feed that is the one I am most interested in. So even there, I think the importance of treating algorithms as expressive things remains important.
Just add a little bit of color to that. So I mostly agree with one, or actually two caveats. On the Moody decision in particular, so like Amy Coney Barrett, can I call it criticism? Critique.
Dissent.
Yeah. Okay. So your perspective of it. I think what that goes to is that there is actually this question of what the First Amendment is. It goes back to that original foundational question, is the text of the First Amendment is the freedom of speech, not the freedom of listen. So there is an originalist perspective that does challenge the notion as to whether or not the listener themselves is entitled to X, Y, and Z. So I do think that there is some aspects of that. I don't want to put words or thoughts into Amy Coney Barrett or any other justice. Like, there are three minds I choose never to get into. One is my mom's, the other is Donald J. Trump's, and the last is a Supreme Court justice. But if I had to venture a guess, I think there is this question of what particular part of the algorithm that is the speech interest here. And so if you are requesting something, if you are doing mostly queries or responding to queries, sounds, I think what got the sense of Amy Coney Barrett or Justice Barrett trying to cabin this into more of a commercial speech context where it doesn't require as much rigor. On the other aspects, even reading the dicta from Moody in the broadest form, it only...
And what is dicta?
Sorry, dicta is non-binding precedent. So there's the actual binding part of the precedent that you can take to the bank. It's an instruction to all courts. This is what the law says. Dicta gives helpful context as to how they reach that decision, but is not something that you can rely on moving forward. So part of what I think Justice Kagan and those who agreed with her on the court were essentially saying was that, okay, yes, there are aspects of the algorithm that probably do warrant some protection, but it seemed pretty narrow. There was a lot of talks about news feeds and being able to curate news feeds. And there was also the actual overall design of the website itself, maybe having some expressive activity. But I don't think the court landed hard on algorithms entirely, especially when Justice Kagan cites to Amy Coney Barrett's concurrence in footnote 5. So I think, if anything, you can bet that whatever the speech interest of the algorithm is going to be cabined by something I think we're all sort of getting around, which is what aspects of the algorithm are the speech. And I think that's what's really going to come down the pike here, is that there's going to be a heavier analysis on what aspects of the service are you trying to regulate? Are you actually trying to get to the content? And even when you see that in comparison with the TikTok case, the question is, okay, well, is the overall purpose of the statute to get to the content, or are you trying to do something separate? And there's this ancillary effect that you have on the content, which the court is saying that doesn't immediately get you into content neutral. And there's even a question as to whether or not the First Amendment is applicable, even with respect to the TikTok case.
So I think it's really interesting because this is all discussion about current technologies platforms that we've had for a long time, algorithms that we've been developing for decades. But this, I mean, it's been long held that code is speech in some capacity. I mean, we can debate exactly which part of the algorithm is speech and is not speech. But at least in my mind, like AI just completely upends this conversation and adds a new level of complexity. So I do want to pass it to Ash and basically just ask, how should we start to begin to think about the ways that AI systems fit into this menagerie of distinctions?
Great word.
I think that's a very important question, and I don't know who has answered it yet. If anyone has, let me know.
Or well, I'm asking you to answer.
Yeah. So far, there's Bernstein. Yep. There is a precedent that tells us that code is expressive, hence most code that is expressive is speech. But now with all the technological developments, we are more veering into a territory where there are certain types of code that exist that probably don't have as many expressive features to it. But we haven't had any precedent that has dealt with that yet. So as far as I know, most of the code that exists that is making decisions about speech would be speech. But yes, I think it's like a very new territory that no one, at least no one I know, wants to really veer into.
I'm asking you guys to veer into it, though. Yeah. Corbin?
So we have Supreme Court precedent saying if it's information, it's protected by the First Amendment. And that's Justice Alito, of all people, who made that clear. Code is information. It is a language. So the presumption probably we start with, it has some kind of First Amendment valence in itself. And that's before we get into, does it create a thing that's on the outside that is expressive in the eyes of a human? And one thing I should note, 303 Creative versus Alanus was this Supreme Court case a few terms back in which a website designer, it was about, well, does she have the freedom to not design a gay wedding website? And the state of Colorado said, look, no. It's a public accommodation law. We're actually making sure that people can't deny service to people based on their race or whatever. And that sounded like a very serious rejoinder. And the Supreme Court said, well, we're not looking at its code or whatever. The end product is a website that is expressive. We're going to get First Amendment protection on this. So I think that case will stand in the way of various attempts to try and get behind the expression and say, well, this is conduct in some way. The Supreme Court can do whatever it wants, so I'm not saying it won't happen, but it would look very result-oriented to keep 303 creative and then suddenly take a very different route in some other context. The question with the code then quickly becomes, well, the AI now are so good at making code that you can just have pure AI code, and things start to get kind of interesting. Joel questioned the First Amendment right to receive information. I have not actually run that to ground as a matter of originalism. It's certainly true that our First Amendment case law is all modern. We didn't even get around to incorporating the First Amendment until the 20th century. Absolutely correct. And then it becomes a matter of, well, do you like the precedents or not? It is worth noting there is a fulsome body of case law on your right to receive information. You can possess obscenity in the privacy of your own home. You can receive Communist Party propaganda if you want. So at the moment, that case law is really, really high. Again, Supreme Court can do whatever it wants. But if it's a matter of, it doesn't matter where the code came from, I, a human, want to receive it. Under current case law, that continues to look like a very strong right. I think where things finally maybe get weird is, so if you have an AI making code some way that is talking to another AI, and it's not like Moltbook, like no human can see it. Yeah, I think things start to get dicey, maybe, yeah.
We're definitely going to get into Moltbook here in a second and kind of agentic. That's the next question, but I want to make sure that I understand what you're saying here, Corbin. Or is what you're saying that kind of if we look at like this 303 case, and if we look at the right to receive information, that at least legally, it's the most important thing is actually user outputs and less about how the AI is designed? Am I reading that right?
Yeah. On an earlier panel about chatbots, there was talk about, we should make the chatbots so that they don't act too human-like. And it rubbed me the wrong way a bit. I actually thought of the meme where sorry to be terminally online for you all, but there's a man and a woman in bed, and the man says, I consent, and the woman says, I consent, and Jesus pops up behind them and says, I don't. What you do in the privacy of your own home, like that's none of other people's business. What I do with a chatbot in my home is not other people's business. That's what the First Amendment right to receive information is all about. And my children, by the way, while I'm at it. So that right, the point is that it is not the state's business what I think or what information I personally want to see. That is my right as a fulsome proponent of indigenous American berserk to do that on my own without a paternalistic regulation telling me what I can and cannot do in terms of receiving information.
I think this really proves that I'm also terminal online, but I've never seen that meme, which really says that algorithms are serving us things we need.
Well, I saw both Ash and Joel shake their heads when I asked that question. So
I think fundamentally, if you're doing things in the privacy of your own home and it's legal, yeah. But I also think that we have plenty of precedent and laws where you can't use a chatbot, for instance, to hack someone. You certainly can't use it to engage in criminal
to be clear,
activity.
yes, but that's right. That's the conduct that you can't go out and do.
So
you can't use code to hack.
You're picking up what I'm throwing down. So I think that, again, it goes back to what the regulation actually is. What are you trying to do? And so this goes back to, I mean, in a very glib way, I said like tech has like this weird First Amendment Tourette's where immediately some sort of restriction is immediately met with some sort of First Amendment defense, or somehow the action involved is imbued with something that the First Amendment actually does hold in revere. And I'm just not totally there. I think it is true, however, that there are aspects of the algorithm that we have to look at and say, to your point on 303, and I think I agree. I just want to make sure if I mess anything up, well, Corbin, you're not shy. So in 303, the issue was the actual implementation. So the question was, look, from a public accommodation standpoint, it's pretty neutral, but the problem is that the neutrality aspects of it amount to something that was trying to restrict you from doing something that's inherently expressive, like, for instance, making the choice of whether you want to serve this type of population or that population as a business. Yeah, okay, I can see in terms of an algorithmic change, if you're trying to manage the inputs at the front end and saying, hey, AI company, you are allowed to use input A, B, and C, but you can't use these other characters of the alphabet. All right, I think at that point, that is the government doing this more paternalistic thing that you describe. However, if you were going back to that originalist perspective, and look, I don't know if they're going to do this. I think I'm reading the tea leaves as much as everyone else is. And the way it seems to be working out is that the question is, what precisely, I mean, what's that movie? Oh my gosh, I can't remember. Anyways, you'll get the meme when I say it. It's when the two Bobs are sitting across the table and they're asking, what precisely do you do here? Office space, thank you. Office space, yeah. I told you'd get it. So I think that's kind of what you're seeing from the court. The court is sitting across from two Bobs, or they're asking either the plaintiffs or the defendants, what precisely is it that you are doing? And what precisely about this regulation impacts your ability to speak?
I really hope a justice takes you up and asks it in exactly that way.
So do I.
Bench at oral argument. Yeah.
Oh, well, they did. Clarence Thomas did mention that one.
Can I ask you, first of all,
Didn't mention office space.
With the office space.
Got it.
In the tone of the guy.
You and me both, brother.
What exactly do you do here?
did you say First Amendment Tourette's? Did I understand that?
That's right.
Like the tick?
Correct.
Okay. I'm still stuck. You said in the beginning that the Free Speech Coalition v. Paxton was like an originalist interpretation.
Yes.
Okay. So I have some of my former students who are not lawyers in the audience, so I know they don't know what originalism is.
I think y'all could debate originalism.
No, but originalism is like a certain type of constitutional interpretation that Supreme Court can use, right?
Do you want me to clarify it?
No, I'm clarifying it for our audience.
Oh,
Before
okay.
I ask
Okay.
you,
Okay.
the follow-up question is like, how do you see Free Speech Coalition v. Paxton as an originalist interpretation of the First Amendment?
I'm glad you asked. So if you look at how Justice Thomas sets up the case, he doesn't simply say, oh, we're going to straight obscenity and we're going to only talk about the Miller test and we're only going to talk about whether or not Ginsburg applies. Ginsburg is a case where they applied rational basis on obscenity towards minors. He didn't start there. He started with Federalist Papers 44, where he said, what is the actual constitutional right of the state? And the Federalist Papers 44 essentially argues that if the state is imbued with certain constitutional rights, then everything to remedy that right is swallowed into it. And so he basically created that framework to say, well, all right, does the state have the right to age gate certain products? And then he went through painstaking detail to describe every time we've applied age gating in the brick and mortar context, he didn't just limit it to obscenity. He talked about whether or not kids were able to buy pills over the counter at a CVS. He talked about the fact that you need to age gate gun licenses. Even for fundamental rights, we have age gating. What I gathered from that was, well, if the state already has this constitutional right, and citing Federalist 44 is a pretty good indication that he's looking at the original founding. He's not consulting a case from 1980. My guess is that's the type of analysis you're going to have to make. What was it that the states have the right to do? And if they have the right to do it in a brick and mortar context, you have to demonstrate why they can't do it in a digital context. So that would be the originalist perspective. That's the originalist reading that I read into Paxton. And look, reasonable minds can disagree.
So we're going to open it up to Q&A here in just a little bit, but I do want to, I was originally going to say that you could do this either from a lawyerly perspective or from a first principles perspective, but I'm going to get rid of the lawyerly for a second.
Oh, man.
Corbin, you brought up a book. Raise your hand in this room if you've heard of Molt Book. You know what we're talking about here.
Oh.
Not quite enough to just roll with it. So Molt Book is essentially a system where people had AI agents that ended up, I'm oversimplifying here, essentially ended up creating their own social media platform where AI agents were talking to each other. They created their own Reddit, essentially. And now you can go, if you're on your laptop right now, you can go look at Molt Book. But it presents this really interesting question from a First Amendment free speech perspective of what do we do once robots start talking to each other? I mean, it's a very silly kind of way to phrase the question, but it actually is a very serious thing to start considering right now because we've already seen it in the wild. So I just want to go down. Ash, if you want to go first, and we can just kind of go down.
Can I go last?
Yeah, you can go last.
Okay.
Like, how should we even start to think about this weird, brave new world where we're going to have AI agents running around talking and doing things for us? Does that simply break like our traditional perceptions of free speech in the First Amendment? Is there a really simple way to square all of this that I'm missing? Just want to throw that out there for us.
So you can okay boomer me if you want, but I typically think that the rights that the First Amendment protects is for humans and not necessarily for robots talking. But if you want to go broader and talk about, well, does this actually advance freer society and everything else? I think that escapes the bounds of what the First Amendment would protect. I don't think that the First Amendment, and I'm interested in anyone who's arguing that like two robots are imbued with a First Amendment right to have that conversation. I don't see it, but that doesn't mean it doesn't exist. But my initial take is that the First Amendment and the laws that are oriented towards either preserving or restricting certain access are more or less geared towards protecting the human condition, not necessarily the artificial condition.
Corbin, thoughts?
So things are moving very, very quickly. And I think from most people's perspective, it's going to start getting very weird. So if I were on the Supreme Court, I would have no appetite to rush into this. I would put it into a few different buckets of when it comes to a human's right to receive the speech that's generated by AI, I've already made my point that I think that right should be pretty strong because it's not about the robot. It's about a human and my right to receive information and think about it and think about what I think about it. And I actually see no reason why speech that's generated from an AI should be treated with any less First Amendment protection than speech from the Chinese Communist Party, a genocidal regime sending its propaganda into the United States. You have a right to receive that. And so I think that's a strong right. People are going to have AI friends and AI relationships. Like, I know that sounds crazy. That's just coming. And I think over the course of time, it will become normalized, but that will probably not be an immediate process. So if we dive into it now, I could definitely see there being Supreme Court precedents that say there's no right here, and then it ends up getting overturned 20 years later or whatever. But as we sit here, I don't think there's any appetite to say the AI itself has First Amendment rights. I think I have a right to see what those bots are saying to each other on Molt Book. The bots don't have any right to speak to each other. And then going back to Joel's point, what's obviously correct is I can't take a bot and have it go do something. And if it goes and sows chaos by breaking into a financial or whatever, like if I use the bot and do some kind of real world harm and violate a law, I have violated the law should clearly be the rule.
I think legal norms come to a head when they actually are tested against what's going on in the world. And by that, I mean, if two bots are talking to each other and we are not aware of that, it doesn't really crystallize if they have First Amendment rights or not until someone tests that theory. And while I think we are in this like sci-fi world in our head, like thinking, oh, like it's just bots talking to each other. But how did these bots come to be? They're probably bots owned by two companies, or maybe even if it's two individuals. And those people have First Amendment rights. And we just talked about some case law that already exists, that code is speech. And so in my opinion, we won't, again, know until the courts test it. But two bots talking to each other, there's probably other speakers that are involved. There is the company that created the code that fed it the data that then, I don't know, read all of Wikipedia and Reddit, and I don't know what's going to happen if both of those merge. And now these bots, or like maybe it's a bot that read all of Wikipedia talking to a bot that read all of Reddit, and that can be a series. But like their First Amendment rights implemented in the company that decided what speech it fed and what data it fed to each of those that exists. So I think there actually probably is a First Amendment right if you just encounter it.
Yeah, I think it's true. If Jackson Pollock can splatter a bunch of paint on the canvas and he doesn't know where it's going to drop or whatever, it's, well, you didn't know where it was going to drop. And so now we have, well, I designed an AI chatbot. Well, what is it going to say? I don't know. There's a strong analogy there. I just wonder if that would actually hold up if we put it to the test in a court.
Yeah, well, look, I think we're all kind of circling the same wagon in that regard. If there is a speech interest that's pretty narrow, I don't want to speak for you guys, but it sounds like you're talking about very specific things that actually do have originalist principles in it. So if anyone wants to see like true tenets of originalism, I mean, we have students here, as Ash has pointed out, a great essay by John Dickinson, who helped draft a lot of the Constitution and it was very influential. He came up with 3 basic tenets of what the First Amendment ought to protect. And so part of it, like to your Jackson Pollock piece, which I really appreciated, is that the First Amendment was ultimately there to advance truth and also to advance the arts and also to help investigate certain things. So I think if there are things in that regard, what I'm seeing is that AI really is asking a lot of us to challenge our first principles and challenge our priors, and also challenge as a country, what do we want to preserve? What do we want to protect? I'm seeing some obvious things like parental rights are becoming more and more of an issue, and that is a fundamental right. You're starting to see a lot of that play out. And also when it comes to the pushback that I think that Corbin was alluding to, you're seeing that balancing test of the First Amendment right of the child versus the right to parent and the AI's relationship in between that. But you're also seeing this question of, okay, what aspects of this AI machine is going to promote and advance this concept of human flourishing, and whatever that means to anyone else. I mean, that's an ongoing debate. But I think ultimately, if you want a high level legal philosophy here, I would really recommend reading some of the initial conversations that you saw when the framers were developing the First Amendment. And can I point to one more thing, and then I'll pass it over to you because I'll just do it. Another thing I would look to too, if you really want to get a sense of what they were worrying about, look at the Virginia legislator, the 2 reports on the Sedition Act, where you have the majority report that was written by James Madison, and then you have the minority report that was written by, well, we think, because it was anonymous, but it's strong John Marshall vibes. And these 2 disagreed and they vehemently fought. They agreed on basic principles, but they fought on the tenets. So I think if you want to see a sense of what we might look to, or what the court might look to, if they're taking an originalist train, it would probably be that, and maybe even like looking at some John Dickinson.
Cool. Well, we're going to open it up now for Q&A. We've got time for probably 2 or 3 questions. So, in the back.
Hi, I have a question and a predicate, but not in that order.
No filibusters.
Yes, I'm Adam Eisgrau with the Chamber of Progress, and I run a campaign called Generate and Create, which, for reasons that will be obvious in a moment, is pro-fair use in copyright law. The question is, what do you think? The predicate is, in this panel on the First Amendment, because it's not complicated enough, I figured I'd mention all this. Fair use is a safety valve in copyright law that the Supreme Court has observed, among other exceptions, is extremely important, or all of copyright law could be so restrictive as to preclude speech, as to violate the First Amendment. So it's a critical safety valve from a First Amendment perspective in keeping the copyright ecosystem vital. The question, what do you think? And about what's going on currently with disputes over AI training, to which fair use is a defense in copyright law.
Just down the line, or?
Yeah, sure. Anyone want to take that?
So I think the concept of fair use has been pretty amorphous, right? Although there are codified doctrines of fair use that you can basically apply, I think the courts are basically figuring a lot of that stuff out now. I don't know if there's necessarily a need to have any individual regulator say this is what fair use is or codifying it or not. I think the courts are basically landing on something that I think is pretty reasonable, which is, look, if you're going to have something on the internet that is not password protected, don't go beyond that. If you go beyond that, then maybe then you might have a copyright claim. But I think this is going to be beaten out in the courts as it always has been, especially when it comes to copyright issues, because I'm sure, as you know, at Chamber of Progress, trying to do anything like rewriting the DMCA, for instance, is basically a non-starter for at least this Congress. A lot of courts are grappling with this. I think they're coming out to the basically good result, simply saying don't go beyond paywalls and making sure that, and also articulating what the right is. So that's probably an unsatisfactory answer, but that's my take.
Anyone else? Corbin?
Yeah, I have enough First Amendment stuff to worry about without lobbing copyright bombs. So I'm pretty
Do it anyways.
Yeah, I'm sympathetic to the view that if you lawfully obtain information and feed it into the training, that's fair use. If the thing proceeds to spit out an exact New York Times article, that is not. And that, as Joel says, the courts will figure it out and hopefully come to something around that equilibrium.
We don't do IP. I'm so glad we don't. So I will just say, I think what we haven't really grappled with when we talk about AI and fair use and in general regulation of chatbots is that we still don't have a federal privacy law that should figure out how much of our data is getting swept up. And those of you in the audience who work in Congress should do something about it.
Next question. We've got one hand over here.
Hello, everyone. James Irwin with Americans for Tax Reform. I believe I'm known to most of the panelists. But Ash, you mentioned free speech rights extending from whoever programmed the bot or built the bot that built the bot, whatever, to the bot itself. And Corbin, you sort of grazed but did not penetrate this issue. We talked about Section 230 liability protections. How do you see that applying in the future to the content produced by AI chatbots and in the context of what you were alluding to earlier? Feel free to just run with that. It's not a very specific question, I know, but...
The guys who wrote Section 230 did tell us they don't think Section 230 applies to speech produced by the chatbots. Doesn't mean that's like the highest authority, because court can interpret it differently. I think when it comes to chatbot generated speech, if it turns into user speech in some way, shape, or form, it becomes protected. Or let's say you go into a chatbot and you give a chatbot such a specific command of, give me a paragraph of an article about the Beatles from Wikipedia. I'm sorry, you were sitting in front of me. From Wikipedia and the top Wikipedia Beatles subreddit. And then because it's like third-party speech that chatbot just ciphered as a tool, probably is also protected by 230, but I think most of it isn't. I know we've said that a lot, but the courts are currently working out for that.
Yeah, no, I think there are isolated instances where Section 230 might apply. Funnily enough, those would be the instances where they'd be violating copyright, which Section 230 wouldn't protect, so they wouldn't want to do it anyway. But in the vast majority of cases, I don't think Section 230 protects what an AI puts out.
I agree.
Can I answer that? I think actually what you're starting to see, the AI companies understanding that, or having that general understanding that Section 230 is actually doing a lot in terms of good corporate governance. So you actually see OpenAI now openly saying, hey, we'll age gate our own products. We'll make sure that kids are protected. Again, I don't want to get in the minds of a corporation or who's making those decisions. But I think by virtue of it not being present, you are getting better results from corporates. So if that trend seems to continue, I don't really like recreating the same mistakes, in my view, that we made in Web 2.0 and transplanting them over to Web 3.0. So as a first principle, I would think that would be a very bad decision.
Well, if we go any longer, Gracie back there is probably going to throw something at me. So thank you, everyone, for coming. Thank you to StateInternet for being such a wonderful and gracious host. And thank you to all three of our panelists for sharing your expertise today.